Welcome back to LiveLaw Daily. I'm your host Debojit Das, and today is August 10th, which is World Lion Day, a day that draws attention to the conservation of one of the world's most iconic and important animals. And there is some encouraging news in India. The country's Asiatic lion population has grown by more than 70% over the past decade, rising from 523 in 2015 to 891 in 2025. With that, let's get into the most important stories from India's courts today. Our first story deals with a fresh challenge to a political shift in the Lok Sabha. Ahead of the monsoon session of Parliament, Lok Sabha Speaker Om Birla approved the merger of 6 UBT faction Shiv Sena members of Parliament. UBT here stands for Uddhav Balasaheb Thackeray. This merger was with the Eknath Shinde-led Shiv Sena. That brought the UBT faction's strength in the Lok Sabha down to 3 members of Parliament, while the Eknath Shinde faction's strength went up to 13. So what is this case about? Arvind Ganpat Sawant, who is a member of parliament of the Shiv Sena UBT faction, has challenged the speaker's decision before the Supreme Court. He argues that the speaker could not approve the merger in the absence of a disqualification petition under the 10th schedule, and that the UBT side was not given an opportunity to be heard. Today, a bench of Justice P.S. Narasimha and Justice Alok Aradhe adjourned the matter for 2 weeks because there was no appearance of the speaker, despite notice being served. Senior advocate Kapil Sibal sought interim relief, arguing that the speaker has no plenary power to approve a merger independently of disqualification proceedings. But the court said that the respondents should be first given time to appear before it considers interim relief. And that is the latest update in this challenge. The matter will now come up after 2 weeks. Our second story deals with the latest flashpoint in the long-running Cauvery water dispute between Tamil Nadu and Karnataka. So what is this issue about? The Cauvery Water Management Authority, or CWMA, on July 30th directed Karnataka to release 3,500 cusecs of water every single day for 15 days from Kabani to Krishnaraja Sagar reservoirs to meet Tamil Nadu's requirements. Tamil Nadu says that the decision has not been implemented. The state has therefore approached the Supreme Court seeking the release of 4.536 thousand million cubic feet of water, which is the equivalent of 3,500 cusecs a day for 15 days. And this is sought to be done by August 12th. And this is the latest update on the case. Chief Justice of India Suryakant agreed to urgently list Tamil Nadu's application after senior advocate C.S. Vaidyanathan mentioned the matter before him. The Supreme Court will now hear the plea on Thursday. The Tamil Nadu government had filed the application on August 3rd, seeking directions to Karnataka to implement the CWMA's decision. The DMK has also filed a similar application before the court. So the immediate question before the Supreme Court will be whether Karnataka should be directed to comply with the water release ordered by the Cauvery Water Management Authority. Our third story comes down to a number that shows just how difficult it is to bring the Manipur violence cases to trial. 891 witnesses are still waiting to be examined in CBI cases alone. So what is the Supreme Court proposing? A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi and Justice V. Mohana has asked the Chief Justice of the Gauhati High Court to consider setting up exclusive courts for the Manipur violence cases being investigated by the CBI and NIA. These trials were earlier shifted from Manipur to Assam. And the numbers are striking, to be honest. The CBI is handling 31 cases and has cited 904 witnesses, but 891 of them are yet to be examined. The CBI has filed charge sheets in 22 cases, with courts taking cognizance in 20 of them. The National Investigation Agency, meanwhile, has filed charge sheets in 15 out of its 30 cases, with charges framed in 7. Given the workload, the Supreme Court said that the Guwahati High Court Chief Justice could consider separate courts for CBI and NIA cases, while shifting unrelated matters elsewhere. The court also directed the State Legislative Services Authority to compile details of the pending cases. And despite reports of continuing law and order problems in Manipur, the court made one thing clear, and that was that the SIT, the CBI, and the NIA must continue their investigations without interruption. Our fourth story takes us to the Calcutta High Court, where a new public interest litigation has been filed over an allegation concerning loudspeakers at mosques across West Bengal. So what is this case about? Senior advocate Kalyan Bandopadhyay mentioned the public interest litigation before a division bench of acting Chief Justice Tapabrata Chakraborty and Justice Abhishek Banerjee. He told the court that loudspeakers had allegedly been removed from all mosques in the state and claimed that the government was acting on oral instructions rather than written orders. Bandopadhyay described the matter as an extremely urgent public interest litigation and also referred to an earlier division bench judgment on the issue. And what has the court said so far? The bench has not yet examined the merits of these allegations. It directed the petitioners to formally file the public interest litigation and complete the necessary service before returning to court. The matter has now been rescheduled for Thursday. So for now, the key point is that the Calcutta High Court has agreed to hear the challenge but has not made any finding on whether loudspeakers were in fact removed across the state or on the legality of any such action. Our next story takes us to the Parliament, where the Lok Sabha has passed a major bill concerning the country's tribunals, but without any debate. And what does the bill propose? The Tribunals Reforms Bill of 2026, introduced by Law Minister Arjun Ram Meghwal, proposes a National Tribunals Commission to oversee appointments, administration and the functioning of tribunals. The commission would have a chairperson, 2 judicial members and 2 technical members. This bill covers 16 tribunals and authorities, including the National Green Tribunal, Armed Forces Tribunal, NCLT and NCLAT, along with the Debt Recovery Tribunal and the Income Tax Appellate Tribunal. Now there is an important bit of legal background here. The bill proposes to repeal the Tribunal Reforms Act of 2021, which was struck down by the Supreme Court in 2025, and that was struck down on grounds including separation of powers and judicial independence. The new bill says that the proposed National Tribunals Commission is being created in accordance with the Supreme Court's directions. And what happened in the Lok Sabha today? The bill was passed amid heavy protests by opposition members of parliament without any debate. The law minister said it does not alter the jurisdiction of any tribunal and is intended to strengthen appointments, independence and transparency. The House was then adjourned till Tuesday. Our next story takes us back to the Supreme Court, where Trinamool Congress Member of Parliament Abhishek Banerjee has got the green light to travel abroad for medical treatment. So what is this case about? Banerjee had approached the Supreme Court after the Calcutta High Court refused to relax a restriction on his foreign travel. That restriction had been imposed as a condition while staying his arrest in a case relating to an alleged provocative remark during the 2026 West Bengal Assembly election campaign. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi and Justice V. Mohana has now allowed Banerjee to travel abroad for 3 weeks for eye treatment. The state opposed the request, pointing to 16 cases against him and arguing that there was a risk he might not return. It also questioned whether the overseas treatment was genuinely necessary. But Justice Bagchi said, every individual has the right to go abroad. Every individual has the right to choose the medical care. And what conditions has the court imposed? Banerjee must travel only on his diplomatic passport and share his itinerary and place of stay with the investigating agency. The court has also directed that his itinerary should not be made public. So for now, the Supreme Court has allowed the medical trip while putting safeguards in place to address the state's concerns. Our seventh story takes us to Assam, where a question over the National Register of Citizens is back before the Supreme Court. So what is the issue? Back in 2019, the final NRC list included around 3.11 crore people as citizens. But the petitioners say that 6 years later, most of these people still have not received the national identity cards that are supposed to be issued under Rule 13 of the Citizenship Rules of 2003. The petitions filed by Jamiat Ulema-e-Hind, the All Assam Minority Students Union and the Assam Sankhya Lagu Sangram Parishad also raise another issue. Around 19 lakh people were excluded from the final list, but they were supposed to receive rejection slips and an opportunity to appeal. The petitioners say that process has not taken place either. And what has the Supreme Court done now? The Supreme Court has directed the Union government and Assam government to file their replies. There is also another petition seeking re-verification of the entire NRC, filed by former NRC coordinator Hitesh Dev Sharma, who has alleged inaccuracies in the list. Since that plea takes a very different position, the court has directed that it be tagged with other cases and considered after the replies are filed. The matter will therefore return before the Supreme Court after the government's response. Our next story brings us to an important question about the media and what happens when a broadcaster's reporting crosses into a victim's right to privacy. The Supreme Court has now dismissed TV Today Network's challenge against a Delhi High Court order awarding 5 lakh rupees in damages for violating the privacy and confidentiality of a child sexual abuse victim by broadcasting details that could reveal her identity. And what was TV Today's argument? The broadcaster challenged the High Court's decision to entertain the case under Article 226, arguing that a media organization does not perform a public function merely by exercising its press functions. But a bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice V. Mohana rejected that argument. Justice Bagchi pointed out that the press contributes to the freedom of speech under Article 19(1)(a), while the Chief Justice of India questioned why a media organization would shy away from acknowledging that it performs an important public duty. There was also a more direct issue here, and that was the victim had specifically objected to the publication, but the broadcaster went ahead with the telecast. The court ultimately dismissed TV Today's plea and upheld the High Court's order. And when the broadcaster warned that this could open the floodgates to similar proceedings, the bench's response was simple: we encourage it. And finally, we turn to Surat, where the Gujarat High Court has questioned both the demolition of homes in Nasir Nagar and what happened to the residents afterwards. So what is the court questioning? The court has asked the Surat Municipal Corporation to explain under what authority of law it is asking families whose homes were demolished to pay for the rehabilitation under the EWS housing scheme. The court was hearing a plea by affected residents, and it noted that a state inquiry is already examining whether the demolition followed due process as well as the role of senior municipal and police officers. And there is another important question. If those officers are themselves under inquiry, why are they continuing in their posts? The court said that allowing them to remain could make the inquiry nothing but a farce, particularly when statements of junior officers may have to be recorded. On the demolition itself, the court said that on the face of it appeared to have been planned in advance, noting the presence of heavy machinery and police deployment, even though officers were allegedly authorized only to carry out demarcation. The court said that the corporation and state cannot shift the cost of rehabilitation onto families whose homes were allegedly demolished without the authority of law. The matter will now be heard next on August 14th. And that's all for today's episode of LiveLaw Daily. We'll continue to bring you the stories that matter without the noise. And for more updates from India's courts, visit livelaw.in, subscribe to LiveLaw's YouTube channel, and follow us on all our socials to never miss an important update.